Indiana Constitution, Article 3, Distribution of Powers. Section 1. The powers of the government are divided into 3 separate departments: the legislative, the executive, including the administrative, and the judicial, and no person charged with official duties under one of these departments shall exercise any of the function of another, except as in this Constitution expressly provided. Indiana Constitution, Article 4, Legislative. Section 1. The legislative authority of the state shall be vested in a General Assembly, which shall consist of a Senate and a House of Representatives. The style of every law shall be it enacted by the General Assembly of the State of Indiana, and no law shall be enacted except by bill. Section 2. The Senate shall not exceed 50, nor the House of Representatives 100 members, and they shall be chosen by the electors of the respective districts into which the state may, from time to time, be divided. Section 3. Senators shall be elected for the term of 4 years, and representatives for the term of 2 years, from the day next after their general election. 1/2 of the senators, as nearly as possible, shall be elected biannually. Section 4. The General Assembly may provide by law for the filing of such vacancies as may occur in the General Assembly. Section 5. The General Assembly elected during the year in which a federal decennial census is taken shall fix by law the number of senators and representatives and apportion them among districts according to the number of inhabitants in each district, as revealed by that federal decennial census. The territory in each district shall be contiguous. Section 6. History. Repealed November 6, 1984. Section 7. No person shall be a senator or a representative who, at the time of his election, is not a citizen of the United States, nor anyone who has not been for 2 years next preceding his election, an inhabitant of this state, and for 1 year next preceding his election, an inhabitant of the district whence he may be chosen. Senators shall be at least 25, and representatives at least 21 years of age. Section 8. Senators and representatives, in all cases except treason, felony, and breach of the peace, shall be privileged from arrest during the session of the General Assembly, and in going to and returning from the same, and shall not be subject to any civil process during the session of the General Assembly, nor during the 15 days next before the commencement thereof. For any speech or debate in either house, a member shall not be questioned in any other place. Section 9. The sessions of the General Assembly shall be held at the capital of the state, commencing on the Tuesday next after the second Monday in January of each year, in which the General Assembly meets, unless a different day or place shall have been appointed by law. But if, in the opinion of the governor, the public welfare shall require it, he may, at any time by proclamation, call a special session. The length and frequency of the sessions of the General Assembly shall be fixed by law. Section 10. Each house, when assembled, shall choose its own officers, the President of the Senate excepted, judge the elections, qualifications, and returns of its own members, determine its rules of proceeding, and sit upon its own adjournment. But neither house shall, without the consent of the other, adjourn for more than 3 days, nor to any place other than that in which it may be sitting. Section 11. 2/3 of each house shall constitute a quorum to do business, but a smaller number may meet, adjourn from day to day, and compel the attendance of absent members. A quorum being in attendance, if either house failed to effect an organization within the first 5 days thereafter, the members of the house, so failing, shall be entitled to no compensation from the end of the said 5 days until an organization shall have been effected. Section 12. Each house shall keep a journal of its proceedings and publish the same. The yeas and nays on any question shall, at the request of any two members, be entered together with the names of the members demanding the same on the journal, provided that on a motion to adjourn it shall require 1/10 of the members present to order the yeas and nays. Section 13. The doors of each house and of committees of the whole shall be kept open except in such cases as, in the opinion of either house, may require secrecy. Section 14. Either house may punish its members for disorderly behavior and may, with the concurrence of 2/3, expel a member, but not a second time for the same cause. Section 15. Either house, during its session, may punish by imprisonment any person not a member who shall have been guilty of disrespect to the house by disorderly or contemptuous behavior in its presence, but such imprisonment shall not, at any one time, exceed 24 hours. Section 16. Each house shall have all powers necessary for a branch of the legislative department of a free and independent state. Section 17. Bills may originate in either house, but may be amended or rejected in the other, except that bills for raising revenue shall originate in the House of Representatives. Section 18. Every bill shall be read by title on 3 several days in each house, unless, in case of emergency, 2/3 of the House where such bill may be pending shall by a vote of yeas and nays deem it expedient to dispense with this rule. But the reading of a bill by title on its final passage shall in no case be dispensed with, and the vote on the passage of every bill or joint resolution shall be taken by yeas and nays. Section 19. An act, except an act for the codification, revision, or rearrangement of laws, shall be confined to one subject and matters properly connected therewith. Section 20. Every act and joint resolution shall be plainly worded, avoiding, as far as practicable, the use of technical terms. Section 21. History. Repealed November 8, 1960. Section 22. The General Assembly shall not pass local or special laws, providing for the punishment of crimes and misdemeanors, regulating the practice in courts of justice, providing for changing the venue in civil and criminal cases, granting divorces, changing the names of persons, providing for laying out, opening, and working on highways, and for the election or appointment of supervisors, vacating roads, town plats, streets, alleys, and public squares, summoning and impaneling grand and petty juries and providing for their compensation, regulating county and township business, regulating the election of county and township officers and their compensation, providing for the assessment and collection of taxes for state, county, township, or road purposes, providing for the support of common schools or the preservation of school funds, relating to fees or salaries, except that the laws may be so made as to grade the compensation of officers in proportion to the population and the necessary services required, relating to interest on money, providing for opening and conducting elections of state, county, or township officers, and designating the places of voting, providing for the sale of real estate belonging to minors or other persons laboring under legal disabilities by executors, administrators, guardians, or trustees. Section 23. In all the cases enumerated in the preceding section, and in all other cases where a general law can be made applicable, all laws shall be general and of uniform operation throughout the state. Section 24. Provision may be made by general law for bringing suit against the state, but no special law authorizing such suit to be brought or making compensation to any person claiming damages against the state shall ever be passed. Section 25. A majority of all the members elected to each house shall be necessary to pass every bill or joint resolution, and all bills and joint resolutions so passed shall be signed by the presiding officers of the respective houses. Section 26. Any member of either house shall have the right to protest, and to have his protest with his reasons for dissent entered on the journal. Section 27. Every statute shall be a public law, unless otherwise declared in the statute itself. Section 28. No act shall take effect until the same shall have been published and circulated in the several counties of the state by authority, except in the case of emergency, which emergency shall be declared in the preamble or in the body of the law. Section 29. The members of the General Assembly shall receive for their services a compensation to be fixed by law, but no increase of compensation shall take effect during the session at which such increase may be made. Section 30. No senator or representative shall, during the term for which he may have been elected, be eligible to any office, the election to which is vested in the General Assembly. Nor shall he be appointed to any civil office of profit which shall have been created, or the emoluments of which shall have been increased during such term. But this latter provision shall not be construed to apply to any office elected by the people.